Good evening, friends. Today, we will try to know the concept of right to be forgotten. And we will also discuss whether it is a fundamental right. What is this right to be forgotten? Whether it is a vested right, fundamental right, as per Indian Constitution. Very important aspect. To understand what is right to be forgotten, let us get into the recent decision of the Karnataka High Courts. The Karnataka High Court case asked 17 media outlets like Facebook, Twitter, YouTube, Google, Yahoo, Indian Qanun, etc. to temporarily block articles, videos, comments displaying the names of two petitioners. What is the grievance of the petitioners? The petitioners were charged in the year 2014 for various offenses under Indian Penal Code. Later on, after a trial, prolonged trial, they were acquitted. So charges were not proved and therefore they were acquitted. Now the petitioners are much more worried because the continued display on the websites, their names, the cases, and the further forwards that are being done are causing petitioners immense professional setbacks, violations of their privacy, immense mental agony, trauma, which infringes their fundamental right to be forgotten. When we have not done any mistake, why it should continue in the media? Now, the court, the High Court, Honorable High Court, after due consideration, gave the necessary temporary injunction and stated, it's a settled law that petitioners have a right to be privacy, right to privacy, which right to be forgotten and right to be left alone are inherent aspects. So it clearly says right to privacy includes right to be forgotten and right to be left alone. What is this again? Right to be left alone. This has also been upheld in the apex court in the case of Justice K.S. Puttaswamy versus Union of India. Then what is this concept? The right to be forgotten is also known as the right to be eraser, the right to erasure. What is this? We will try to know. Whether it is a fundamental right that should be assured to every citizen of this country. In the modern explanation, we come to understand that right to be forgotten is to remove the personal information, photographs, videos from the public available resources. It could be internet searches or many more. But I feel this is very narrow and inadequate. What is the purpose of right to be forgotten is he should get relief from all sources of media, even including printed media, because he is a person who requires that protection for living a dignified living of a human being. Otherwise, lifelong he has to be serving that for which he is not responsible. So there, the principles have to be built around the philosophy of preserving the dignity, the self-respect of an individual in a civilized society. Should cover print media also, government records also, digital media also, internet, or any other means where this communication is done. We should try to protect the person from such privacy. So why this is required? As you know, every human being must determine his life in an autonomous way. He should not be perpetually defamed, stigmatized, that too for a past performance. We may do a lot of mistakes, lot of errors, lot of unhealthy practices in our past life. But when we have changed ourselves, why this should linger behind? Why that should catch up with us? And why people should know about it? Because if that remains there, my future is also becoming bleak. I have no opportunity to reform myself. So this is the concept that it needs to be understood to find out the requirement of right to be forgotten as a fundamental right. So should individuals have the right to make damaging information disappear? The answer is yes. If it is not in the public interest or whatever may be the limitations that could be fixed under the law, except that after a certain time, it should disappear. Otherwise, it's not at all fair, justifiable social practice. It's a part of privacy right. It's vested with every individual. That is to protect his or her sensitive, private, personal information. It could be any devices, measures, or device tools that are being used. All of them, from all of them, he should be protected. Sir, whether there are other documents which will protect, the International Human Rights Instrument or the Constitution of India have not expressly recognized it as a fundamental right or a fundamental requirement of an individual. Very unfortunate. We need to look in, because as digital technology is spreading, widespreading, and this is become a common goods where information can be exchanged simultaneously across the globe in no time with least expenses, we need to relook into protecting the right to be forgotten rights in an individual. Because it is required to protect a human being's reputation, honor, and dignity. It should be also expanded to non-digital traditional communication modes also. That's what I feel. Sir, whether internationally this has found a recognition, because the digital technology came in other countries far earlier to India. The answer to this is yes. It was first developed in France, then to Argentina, and it has spread all over the world through privacy laws. Even GDPR, Article 17, enables this right. But how about in India? We do not have a law to protect the individual's privacy, nor right to be forgotten as a right, which is included in the right to be privacy. But whether the codes are of the different version where law has not been made, the answer is yes. In Karak Singh versus State of UP in 1963 itself, the Honorable Supreme Court recognized the right to privacy as Article 21, right to life and personal liberty. Kindly note this. In 1963 itself, the Supreme Court has held. But we have no law for this till date. For every dispute, the citizens, the aggrieved person, has to approach the court, which is very, very unfortunate. The court, in its decision dated 18/12/1962, held that certain provisions that allowed the police to make visits to habitual criminals, individuals likely to become habitual criminals, are unconstitutional. Even though police rules provide for it, it is unconstitutional. You should not visit them on a routine basis. Because he might have reformed, the criminal might have reformed. When there is no reported or information about such things, regularly visiting their houses, harassing the persons in their residences are uncalled for. It is unconstitutional. Similarly, in the case of Punjab versus Gurmeet Singh in 1996, the Supreme Court held that anonymity could help to protect the victims of sexual offenses from social ostracism. So in 1996, they have said don't publish the names of certain crimes, especially if it is a rape and the victim is a lady. We should be very, very careful not to mention their names. This is again reiterated in Puttaswamy in 2017. So the courts have been holding that right to be forgotten is a fundamental right, not a fundamental right, as a right. Now in Supreme Court, case Puttaswamy clearly says it is a fundamental right. The right to privacy is a fundamental right flowing from the right to life and personal liberty. Right to be forgotten. He makes specific remarks. If you were to recognize a similar right, it would only mean that an individual who is no longer desirous of his data to be processed or stored should be able to remove it from the system, where the personal data information is no longer necessary, relevant, or incorrect and serves no legitimate interest, that should be removed. It has the right vested in the citizen, fundamental right. But Supreme Court is very cautious. No fundamental right can be absolute. It will go with certain restrictions imposed by the law. Similarly, right to be forgotten should be with certain riders, like if it is an exercise of the right to freedom of expression and information in the public interest, it is required to remain in the public media. Similarly, fulfillment of legal responsibilities, execution of a duty in the public interest or public health, if it is desirous of getting that information there, and for the purposes of scientific or historical study, statistical purposes, specifically it should be allowed to be remaining in the media, in the internet, the establishment, executing or defending of the legal claims. So these are all the exceptions the Supreme Court of India has provided. This was also part of our B.N. Sri Krishna Committee's draft Personal Protection, Data Protection Act 2018, which never saw the light of the day, though it was placed as PDPP Bill 2019. Now, Government of India has withdrawn the stated law. However, in India, there is no law specifically providing for RTBF as a fundamental right, and that is a necessity. Otherwise, what will happen? It will cause psychological and emotional sufferings to the individual. It can affects his present life. That's very essential for him. So, RTBF, if allowed without any restrictions, may also result in certain circumstances where violation of freedom of expression may occur, and therefore, with suitable riders, restrictions, this should be declared a fundamental right. There are also challenges in the journalistic field where reporting may be difficult, and also in crime investigation. This is a necessary information required where we can provide as an exception. On this, our cyber expert Navi observes, companies which are doing background verification to check if a prospective employee has in fact committed any fraud or terrorist activities in his previous assignments will find that no information may be available anywhere. As a result, cyber crime prevention will seriously be affected. Yes, that's one area where we should have public interest, and criminals' names, if they are proven guilty, we should allow it to linger there. Now we will look into the digital scenario. As you know, the Aadhaar registrations without any basis of law resulted Justice Pustaswamy petitioning in the Supreme Court law, and the decision is right to privacy is a must. And Supreme Court, as I told you, also has held the right to be forgotten is embedded in that. The other later information have no relevance as government has withdrawn. In the meanwhile, Chris Gopal Krishna Committee gave more focus on non-personal data and data commercialization. Recently, we had intermediary rules guiding how intermediaries have to be responsible. But these protections are inadequate, and especially as far as right to be forgotten are concerned. So law covering personal data protection, incorporating right to be forgotten, are to be made on top priority. That's what I feel. Friends, in the present day digital society, wherein information exchange takes place in immeasurable speed, right to privacy and the right to be forgotten, both of them should form part of the inalienable fundamental right and a part of Article 21. However, in the interest of fair justice, the author feels that reasonable restrictions should be incorporated into such a legislation so that right to be forgotten remains a fundamental right subject to certain restrictions as prescribed in the law. Thank you.